Webnyay would like to welcome you all to this webinar on dispensing justice through online hearings. We have with us our distinguished speaker, Shri Bimal Julka, and I take this opportunity to welcome him on behalf of all of us. I am Siddharth Garg. I am a practicing lawyer based out of Delhi. I practice across all forums in Delhi in civil, commercial, and arbitration laws. I would be moderating this session. Just to give you a brief introduction on what Webnyay is, while most of us would already be knowing about what it is, I believe this is an opportune moment to provide some further context. Webnyay's name comprises of two words, web for the cyberspace and nyay, the Sanskrit word for rules, judgment, and justice. Webnyay's mission is to take justice to everyone's doorstep and increase access to justice in India. Webnyay has two product offerings. The first product is called the CDR or Commercial Dispute Resolution, which is to resolve B2B, B2C, C2C complaints, conflicts, and disputes. It is a one-stop place for businesses looking to resolve civil or commercial disputes as well as complaints and grievances. Webnyay is the only ODR provider that uses document automation technology to generate legal pleadings and formal complaints in the dispute resolution process. Webnyay also works with experienced professionals that act as neutrals on disputes being resolved on the CDR platform. Webnyay's second offering is the RV or Resolve Virtually platform. This is a plug and play technology system that can be used by anybody to resolve existing and future disputes. For instance, arbitrations where arbitrators are appointed by the High Courts or Supreme Court under Section 11 of the Arbitration and Conciliation Act can be conducted online on the RV platform. Similarly, the platform can be used for mediations, conciliations, and other modes of dispute resolution. Both of these platforms can be accessed in numerous Indian languages and have advanced features like virtual hearing room and private meeting rooms with video recording and transcription capabilities, cloud storage to store case documents, a global calendar to record all hearing and meeting dates, and Aadhaar authenticated digital signatures. Webnyay also offers a 24/7 IT support and a dedicated legal case manager to ensure a smooth hearing and meeting experience. For further details, we invite you to visit their website www.webnyay.in or email them at admin@webnyay.in. Both these links will be available on the chat screen. Without taking any further time, I would now like to introduce our distinguished speaker. Mr. Bimal Julka is a retired IAS officer of the MP Cadre and was formerly the Union Secretary of Ministry of Information and Broadcasting. He also served as the Chief Information Commissioner. Presently, he is a practicing arbitrator and is highly respected in that field. We welcome you, sir. Just to start this session, we know how technology has really supported us in today's times. During the pandemic, this has come out as an effective means of dispensing justice. So in that context, we would like sir to give us an insight and perspective on online forums being used vis-a-vis Right to Information Act and also for arbitrations. So if you can just tell us, sir, how did the information commissions across the country go virtual when COVID-19 hit India and a national lockdown was imposed? If you could please tell us something on that.
Yeah, thank you very much, Siddharth. First of all, at the outset, I would like to thank Webnyay and your entire team of officials for inviting me to this forum. Let me tell you that I was not aware of the background of this forum till you introduced me, and I just learned how marvelous work you're doing on the judicial side. And these are all innovative and creative work. And I would like to convey my best wishes to you and your team for continuing in future endeavors. So thank you very much for introducing me to Webnyay and also for inviting me at this forum. Thank you very much. As far as you raised the issue of technology and RTI, but before I commence the problems and how we dealt with the technological issues during the lockdown period, I would like to first take you through the preamble of the RTI Act. You must exactly know, I think all your viewers also must like to know that what is the preamble. The preamble of the RTI Act says it's an act to secure access to information under the control of the public authorities in order to promote transparency and accountability in the working of every public authority. So transparency and accountability, you see, these are the key words in this preamble. It also says harmonizing the conflicting interests. How do you harmonize? You talk about informed citizenry, transparency of information vis-a-vis other public interests, including efficient operations of the governments, optimum use of limited fiscal resources, and preservation of confidentiality of sensitive information. Now, this is the background on which we actually move in the RTI. Now, in the commission, every official is very much aware of what exactly is the preamble to the RTI Act, and we have to follow it in letter and spirit. Now, coming to the issues and the challenges that we faced during the pandemic and the lockdown, I'll just in nutshell, I will tell you basically, 23rd March, as you know, that was the date in which the lockdown was announced. And we deliberated on this issue on 24th itself and had a very hurried kind of meeting with all my commissioners and the commission representatives. And we decided that maybe for another 10 days or so, because at that time it was the peak of lockdown, we didn't want the courts to keep on running because all the issues had to be resolved in-house. And so that's why we postponed the hearings till about first week of April. And we thought that by 31st of March, we will review the position, how the government directives are there, and how the people are able to adapt to those directives, and how we are able to reposition and reorient ourselves as far as the functioning of the commission is concerned. So we had taken precautionary measures. You know that the first and foremost responsibility of mine as the Chief Information Commissioner was also towards my own employees, that their health and safety and security, that must be ensured. So we took precautionary measures in the wake of pandemic, and such as social distancing, staff allocation in various departments and registries. That's how we did this thing, allowed them to work from home. Periodic sanitization of the CIC premises, because this we had not thought of earlier, but urgent measures had to be initiated to sanitize the office of CIC, the whole office building. Thermal scanning, sanitization of all persons entering the CIC premises. So in a very efficient manner, all this equipment had to be installed. So we did it in a great hurry at that point of time. Contact hand sanitization of all persons entering the courtrooms. So we placed dispensers outside the courtrooms. I'm giving you a virtual experience of how exactly we implemented the whole thing. So all the dispensers were placed outside the courtrooms. So even if the local staff was coming, they had to, get the dispensers, go through them and sanitize their hands and all, so that they attend to the courtroom in a sanitized fashion. Then hearing for all urgent matters allowed through video conferencing and audio conferencing. So exactly on 5th of April, we started commencing hearings of all our cases through audio and video conferencing. We said, dispensing justice is the critical aspect. So public should not suffer on this account, because the larger public interest is the key word as far as the dispensation of justice is concerned. Then facilitation of written submissions. We were facing handicaps as far as the email addresses of the parties are concerned, because the applicants, the respondents, they were never used to providing their email addresses. So they used to give those physical copies, they were sent by post, etc. So we started collecting the e-addresses, also their phone numbers. And under the RTI Act, as you know, the people are very sensitive to disclosing their own phone numbers because they don't want to disclose the identity of the individual who's filing an RTI application. So that was another big challenge, that how to get hold of their phone numbers. So we contacted them somehow, whatever traces were available, we somehow got hold of all their phone numbers, and contact details of all the deputy registrars were uploaded on the website. We ensured that the website of the CIC should be made functional, operational, and it should be up to date, because that is the first point of contact for any common man or a citizen who looks at the website. He must know what exactly, whom does he have to approach. Their contact details, their mobile numbers, their phone numbers, everything was listed out, emails also. Then link on commission website was notified. Whatever links were there, they were fully notified so that anybody who can have access to the internet, he can see those links. Notices we started issuing through e-posts. And I must say that the postal department came in very handy and was very helpful in facilitating the sending of our posts. So e-posts system was resorted to. Emails were sent to the CPI wherever we had, because there are almost about 2,900 public authorities within the government of India. I'm talking about the central government only because I speak as in charge of the Central Information Commission. So we were dealing with almost about 2,900 to 3,000 public authorities. Now these public authorities, wherever nodal officers details were available, we sent an email to them and told them to please contact the concerned CPIO, because as you know, in a particular department, there could be 15, 20, 30 CPIOs also, depending on the strength of that department. And so we sent it to the nodal CPIO so that he acts as the single point of contact who can access information, facilitate information through by contacting his colleagues, because we thought he would definitely be aware of the telephone numbers and the email addresses of his colleagues. So that is how this information was collected. Then online registration and scrutiny of received fresh cases was being done on the same day. We activated the online submission of applications. Anybody could send it through online, and we tried to register the applications then and there itself without taking time, so that we could at least start the process of hearing. And at the same time, what we did was that alternative working methods, that is work from home, it was adopted with intensive use of technology, and e-office was extended to home computers of the officers. As you know that the e-office is available only in office. During the office premises, you can get access to that. But then what we did was, because of this peculiar position and extraordinary circumstances that we were confronted with, e-office facility was provided to the people and the staff and the employees at their homes, so that in case they have a laptop or a desktop, they can access that information. Another issue was the digitization of records. And I must say that this exercise had been undertaken in the commission about 3 to 4 years earlier. And that came in very handy, because the application that you file, naturally, when you are sitting at home, you say that I don't have access to what application I filed and my case is being heard. And at this time, I can't even retrieve those records. So in that case, what we did was we had digitized the records, scanned all the copies, so that your application, all the enclosures that you submitted along with the application, and the respondents' response, because the respondents were also public authority officials and they were working from home, so they didn't have access to their records. So what we did was that we scanned those copies of their records, also their replies. We posted it in the digitized manner on the portal itself. So as a result, if I could just click on the appellant, his response or his application, I could immediately have access to what information was sought by him. And similarly, if I tapped on the respondent's reply, I could tap what was the reply given at that point of time. So even if the respondent or the applicant was available at their home, they could access records through their laptop by just clicking on the concerned website and they had access to that information. So at least that recall facility was there, that I could recall, yes, this was the reply which I had given at that point. So we said that this is how we can at least facilitate. Then in the meanwhile, we also did one important thing was that we engaged with the civil society organizations. So civil society organizations, I said we must engage with them, take them into confidence and seek their support and guidance as to how best we can address the situation of dispensing justice in these present extraordinary circumstances. And I must tell you that we received very useful, very productive, effective suggestions from the people from the civil society, as also the Federation of Information Commissioners, that is all the state commissions. We engaged them also in a dialogue through a webinar like this. And we said that you tell us how you are doing it so that there could be exchange of ideas, so that's how we could get the maximum outputs out of this. As also the previous chief information commissioners, all those chief information commissioners who were there, they were contacted. Each one of them was contacted on laptop. We organized a webinar, had their suggestions that how best we could address it. So these were some of the issues that we tackled at that point of time. And I must say that the commission handled very well the situation during these extraordinary times. And our disposal in the month of April and May was a little less, but in June onwards, it picked up immensely. And I'm happy to state that even if you see the corresponding figures of the last year and this year in 2020, the disposal rate was much better. And in fact, the both the parties had got used to coming online, and they were saying, why are you not discussing on WhatsApp or through audio conference, etc. And why are you asking us to come to the NIC studio? So I mean, that is the kind of the culture which emerged over a period of time. So these are just some background of how we proceeded.
Right, sir. Thank you so much for that. So as you mentioned that the preamble to the RTI Act itself talks about transparency.
Yeah.
So would live streaming of RTI hearings on virtual platforms bring transparency, more transparency in fact?
I think there is no harm in bringing this live streaming because we never disallowed any public representative from attending any of the RTI hearings. In the commission, in fact, if you had just seen any of the cases, the way the adjudication process was dealt with, we provided opportunity to everyone to attend the courtroom. He could come, like the respondents, for example, they used to come with 7-8 colleagues of theirs, and they used to be present in the NIC studio. And if they are present, we don't know who all other people are. And similarly, as far as the applicants are concerned, we don't know who all are sitting with them. They could also bring their own people. So as a result, it was open to everybody because there was nothing to hide. And I feel this is the beauty of the RTI Act, that we bring in absolute transparency and accountability. And and most judicious decisions are given by the commission in these manners.
Right. Well, sir, as you mentioned that the disposal of cases has increased, in fact, for the last few months. So, can we in fact conclude from that that the backlog of cases information commission and virtual hearings can help in efficient disposal?
As far as this issue is concerned, I feel that we must look at advantages and disadvantages of virtual hearings. You're a lawyer yourself, you would know
Yes.
better that how these virtual hearings can be. And there are, of course, difference of opinion amongst various judges also. I think we keep reading in the papers also how they look at it. But I feel as far as the advantages of virtual hearings is, number one, it's a very cost-effective method. It's a cost-effective method of providing justice. It reduces carbon footprint and substantially reduces the attempt of employment of dilatory tactics of the parties. So to that extent, it's very, very useful. It will also reduce thousands of transfer petitions and cost effectiveness from parties' perspective. So the party's perspective, it's a very, very good and very judicious mechanism of providing justice. Now, however, I think it should be made optional for the clients and the respondents, whether they would like to go through the virtual hearing process or they would like to go through the physical hearings as and when the pandemic subsides and there's an environment for physical hearings. That's, of course, a different methodology. Now, it reduces difficulties for traveling of both the parties, because otherwise people are coming, especially in Delhi. We noticed that in NCR region, people had to come to the commission to present their case. So I think it reduced the difficulties of traveling, and even confidentiality was protected through virtual hearings. And in arbitrations, I feel it is much more useful, and it's good to strengthen this mechanism further. That is what is the primary, a few issues that come to my mind. Now, as far as the problems and disadvantages are concerned, if you have time, I'll just elaborate on that. Number one, and first and foremost, what we experienced in the commission was technical glitches. There are many technical glitches which take place, which disturb and break the entire hearing process. Then there are software constraints. Then what kind of software, what kind of platform you're using, like you're using these Teams, others use Zoom. There was, of course, an advisory issued by the Home Ministry that Zoom should not be used. So all those kind of issues are there. So these are all third-party platforms that we are using. So those software constraints are also an issue to be dealt with. Then the status of application and repeated calls. How do we ascertain the status of application? If I am sitting at my place, do I know that the status of my application, if the website is not properly maintained or updated, then I will not know what is the status of my application. And then I'll have to keep repeating, repeatedly call you. And sometimes your phone is answered, sometimes your phone is not answered. So all those practical issues are there. Then emails and phone numbers. Sometimes the emails, they bounce back. They don't, go through. So that we experience in our day-to-day life also, and the phones are also remain unanswered. So those kind of things are there. Then the link which you provide through the email, for the hearing, for example, it's a Google Meet or WebEx or whatever you decide. Now that link becomes inactive or is not getting connected. Now those challenges are there before us. So sometimes we did face these issues that it suddenly, the screen will go blank. And as a result, the parties would assume that the hearing has come to a close, whereas the hearing was still continuing. So we could not handle that kind of issue. These are technical problems. Another issue, I think vital issue and critical one, is about the training of the manpower. Now, these kind of situations, when the people are not experienced, they didn't know how to handle these kind of technology tools. So the training of the staff is very critical. So I think we need to prepare them for future, because the way things are going, you never know where the pandemic, when it will be subsiding. I think the technology has to be more and more in use. So adoption of digital tools is going to be the law of the day. Then discipline and infrastructural constraints, the bandwidth issues. For example, when I dealt with the state governments, I told them, I said, look, everybody is complaining that you are not dispensing justice and your hearings are not continuing. They said, sir, we can't even get through our people because the phone connectivity, internet connectivity is not there with the remotest areas. And in RTI, as you know, we don't deal with only metropolitan cities. We deal with the people in the remotest of areas. And he can file an RTI application and he must be accessible. So I could not get the connectivity to them. So that was another constraint which we faced. Now, issue was basically that the stakeholders, I feel that they must come together to improve the judicial administration in the country. So all stakeholders, whether they are telecom authorities, different telecom authorities, or Ministry of Home Affairs and other all stakeholders involved, they must come together to improve the judicial administration and properly, outboarding India's courts to a standardized, secure, and functional virtual setup. It's definitely a complex task. and it requires a lot of efforts to come together and ease out those issues before we are able to dispense justice. I mean, these are some of the issues that we felt were critical.
Right. In fact, that was one of the questions that we had. In fact, that there are so many challenges that every commission or the tribunal would be facing in building that digital infrastructure. So particularly, I mean, you've discussed those challenges, and you've also told how the stakeholders should come together and work towards an effective platform. But are there any specific suggestions, more suggestions that you would want to give, sir, with vis-a-vis building a digital infrastructure, particularly for the information commissions?
Now, as far as the government authorities are concerned, I feel that we should look at an exclusive software to be developed. Let there be an
Yeah.
exclusive software which should be functional. Right now, the National Informatics Center, NIC, has developed a video software, VIDYO. Now, that
Right.
software is only applicable when the parties are coming to the courts, to the NIC studio. Now, if you are not in an NIC studio, that software may not function. So somehow, we have to develop a software and its accessibility and reach to the remotest corner. And I'm sorry to say that, we invited a lot of software companies during that time itself. And we told them, confronted them with the problems and the challenges that we face. But till date, we were not able to get a very viable solution to the kind of challenges that encompass the commission. Then third party software, it's a security hazard also. You're using a third party, you don't know how the data is being extracted by the third party, what he is doing with that data, because there is sensitive data also which gets transmitted in the transactional analysis. So I feel that those issues are also to be dealt with very succinctly. And administration of justice is very, very critical. Maybe I think we could look at the blockchain technology, which could make a use of transaction of data safer and secure. I don't know, but I am not a technical expert, so I will not like to give my final verdict on this. But these are some of the suggestions. I feel that it's important. Then poor quality audio. That even if you are trying to connect them on, there are 5 or 6 people to be connected at the same time. Now, is it possible to get clarity? Sometimes, the phone is blurred, the noises is there, you cannot hear the parties. So I think those kind of issues also have to be dealt with very, very accurately and meticulously. Then frequent loss of connections. Once what happens is that once you're connected on phone, in Delhi itself, sometimes you are speaking to somebody and the call gets disconnected. So now, if you suppose you are not able to connect and you have a certain time period reserved for the that case, and that matter is under adjudication before you, so you lose the full track of exactly how the discussions were going on, what kind of arguments were being put forth by both the sides. So those issues are there. Then high latency affects, judicial assessment of demeanor and emotions and other non-verbal cues. You do feel, that in virtual hearings, unless you are on the screen, I mean, I cannot make out what exactly is your body language, what is your demeanor, how you are responding to the particular issue. So then the judge also makes some kind of an assessment of how you're proposing to do it and how much commitment and conviction you have in that statement that you make. So those kind of issues also are important. So I feel that there should be courtrooms, which should be appropriately designed, maybe customized with the hardware and software to facilitate virtual hearings. And they should be soundproof, and I think over a period of time, we are realizing it on a day-to-day basis that this is the need of the hour.
Absolutely.
Yeah.
Well, from a practical point of view, in fact, sir, this question, in fact, comes to our minds that several times when the appellant or the PIO would say that they had given a particular defense, however, the same was not taken into consideration by the Information Commission, as a result of which the appeal was dismissed or it was allowed, whatever. Now we are seeing that live streaming can be done to not give them enough room for suspicion. They can revisit the hearings this way and see that the arguments were considered. So recording of these online hearings obviously will definitely reduce that room of suspicion. So what are your thoughts on that?
I think that is a call, it's a policy level decision which the government has to take. So I would not like to comment on it because I don't know what is the practice being followed in litigation in the courts, for example, Supreme Court and High Court, how they are following. But I think a view can always be taken by the government in this respect.
Right. And another thing, sir, do you think that information commissions somewhere suffer from shortage of support staff for, I mean, if the technology can be used to cover for such shortages?
I think as far as the staffing requirements are concerned, always there is a need for extra staff. People keep on asking for extra staff. But I think what we need to do in-house is to assess how judiciously are we utilizing the existing staff. So
Right.
I feel as far as the Central Information Commission is concerned, we had adequate staff. It was only the skilling and the upskilling of the staff which was a problem. So I think if they are trained and skilled in a particular direction, then they can deliver. There is no problem for extra staff to be recruited for that purpose. But the state
Right.
governments, of course, I think during my interactions with the state commissions, they did raise this issue of shortage of staff. But you are right that technological tools can address that issue also adequately.
Right. Well, sir, because while doing my research on this topic, in fact, I came across, for instance, in the State Information Commission of Madhya Pradesh, in fact, there was an state information commissioner who had, in fact, raised this issue that as support staff, he would only get two people. There were no registrars in MP State Information Commission. So accordingly, they were facing a shortage of staff in the sense that those two people had to maintain the database, connect with the litigants, assist the Information Commission, and those are the issues that were constantly coming up. So in that context, yes, sir, thank you so much for your response on that. Well, sir, another question would be that uh, if you were to request and build a dedicated application or software for information commission, what specific features would the software have? We've heard from you, you've in between mentioned your answers that certain things like providing technical qualifications to the support staff is a must. So, in that case, are there any specific features that you would look at for the Information Commission's software or the application?
No, I personally feel that any kind of software, number one, it should be user friendly and it should adapt and address the issues of the public. So
Right.
I feel it's just like a link which you have provided. If I click on that link and I immediately get across to you, that saves my problem because the parties are not interested in what exactly are the technological tools deployed by various commissions. They are interested in how adequately and appropriately we are able to address their grievances and their
Right.
applications. So
Right.
those kind of issues, they need to be dealt with by a technical team, but I feel it should be user friendly and it should address the needs and aspirations of the public so that they remain satisfied.
Right. So apart from that, we also know that since you retired as the CIC, you've also been engaged in numerous arbitrations. So if you could just highlight your experience on arbitration hearings during the lockdown that have been taking place virtually, and what particular virtual hearing softwares or applications you've been using, and are you happy with them?
Yeah, I think that is a very, very valid question. I think ever since I retired, I was offered some arbitrations with the Indian Council of Arbitration and other government bodies. Now, it's been a very useful experience there, and I feel that we have been holding courts through Zoom, by and large through Zoom link or through WebEx or through Google Meet. So these kind of technological platforms are being used by various groups. So out of all these, I find that the Zoom link has been somehow very audible. The clarity is there. The video quality is much better. So we are able to, it's just like a real life situation. So I think there are 7 or 8 parties who present their viewpoints at this forum. And the 3 arbitrators, the 2 of them judges, also very senior judges of the High Court, and myself, I think we are able to hear them very properly. We know what exactly are the issues that they raise before us, the reasoning, the arguments, and the paperwork which they present before it. They share the screen and they show everything on the screen, all the judgments that they rely upon. I think that's going on perfectly fine. So I think similar such software is required even for the information commissions, so that we have access immediately, and it facilitates in decision making.
Right. Yes, sir. But what about recording of evidence? I mean, how do you see the cross-examination of witnesses, especially being conducted online? Because as you rightly mentioned, that even the judge would want to observe the body language of a witness. Similarly, a lawyer who is cross-examining a witness would want to see the body language of the witness and to ensure that the witness is not being tutored. So these are some practical difficulties that come in cross-examination of witnesses and recording of evidence. So what safeguards do you generally see or order for the parties to put in place?
No, as I told you that, there are pluses and minuses in each kind of situation. Now, definitely virtual hearings, cannot be substituted for the physical hearings. But the fact remains that extraordinary circumstances required extraordinary actions. Now, we are dealing with extraordinary situation. So in the best possible mechanism and the methodology that we have before us is to use any of these platforms. And I think as far as putting forth arguments, reasoning, and the content which is provided on these platforms by each of the parties, it's being fairly well presented, and we are able to see them, we are able to hear them. The quality of audio and video is very good. So I think we should have these kind of virtual hearings till such time we are able to come back to the physical hearings, so that will take its own time.
So can we assume that you prefer physical hearings over virtual hearings for arbitrations?
Not really, not really. I'm quite happy with the virtual hearings also. As I told you, it all depends upon the software and the clarity with which the software addresses these issues. So far, the softwares that we have encountered, I feel that I am quite satisfied with those softwares, and they're able to address the issues. As far as the third party security hazard is concerned, I mean, those issues need to be addressed by the cyber law experts and all. So I am not commenting on that.
Right. How can online dispute resolution increase the access to justice and lead to effective and transparent governance in India?
No, it is a very good and a very judicious way to dispense justice in the shortest possible time. Because what I observed is that as far as the information commissions are concerned, I mean, somebody was just doing shopping during the lockdown period. He was at a ration shop, and the moment a call went from the commission, he immediately answered that WhatsApp call wherever the video WhatsApp was available. So he could answer that call, or we could even have just an audio call with him, and he was very readily available. Sometimes, in fact, in a lighter vein, I could say that when the hearing commenced, 1 or 2 parties, when I contacted them, He was literally in their half pants and all, and they said, please let me get my the shirt and let me wear the shirt and then come back. So those kind of things. As a result, what had happened was towards the end, I think in August or something, when we started doing these hearings and told them that now we are resorting to gradually coming back to our original system of coming to the NIC studio, there was a lot of resistance from some of the applicants because they enjoyed being in the vicinity of their home and attending to their
Right.
household chores, as also addressing the problems which they had raised before the commission.
Certainly. So just to have some questions from the audience, Mr. Ranit has a question that
Yes.
can commissions move online permanently once the pandemic is over? Should the commissions move online?
I think it's a very good suggestion. And as far as the Information Commission is concerned, I think in Central Information Commission, we had resorted to this online mechanism. Virtual hearings, in any case, were already there. Online is only thing is that as long as you are able to put across and there is an element of satisfaction, it all depends upon the litigants whether they
Right.
feel satisfied with online hearings or not. So that is something I think the parties have to themselves decide. If they prefer that mechanism, I don't think commissions have any problem to do that.
Well, another question is upskilling the information commissioners and the staff in operating this new platform of virtual hearings. So, can this be outsourced to private players like Webnyay? That's a question from Mr. Ranit again.
Yeah, that is, but right now, I think in the commissions, possibly, it's the National Informatics Center, which is the custodian of all the platforms and all. So that again, it will depend on the policy level decision by the government. If they prefer to outsource, then they can. But till date, it's always been National Informatics Commission, which is helping us out in this area.
Right. Thank you so much, sir. Are there any other questions from the audience? You can please post them on the chat. Well, I don't see. So, I would now like to invite Mr. Puneet Jindal, Senior Advocate, to give the vote of thanks. Mr. Puneet Jindal is a designated Senior Advocate and has been practicing since 1986 in the Supreme Court of India, High Court of Punjab and Haryana, Delhi High Court, and High Court of Bombay. He also has an extensive practice in various tribunals, including the NCLT and NCLAT, DRT and DRAT, CAT, Consumer Commissions, etc. He frequently sits as an arbitrator in commercial disputes. He advocates for increased use of technology in the justice delivery mechanisms, especially online dispute resolution, and is an advisor to Webnyay. We are glad to have him here with us, and he will be delivering the vote of thanks for this session. May I now have Mr. Jindal? Yes.
Thank you, Siddharth. And on behalf of Webnyay, I would like to thank everybody for attending for attending today's webinar. A very special thanks to you, Mr. Julka ji, for being with us today and sharing your rich experience. I would like to thank Siddharth for moderating the webinar. I have learned a lot from this session, and I hope everyone attending also must have gained from today's discussion. As is obvious, with the experience of Julka ji, that this now online dispute resolution is a thing which is most likely to catch up. And of course, there were teething problems, which of course we can see, because suddenly it has now being adopted. Well, at least I am a big believer that this digital courts and online dispute resolution, online hearing is going to stay. As very rightly discussed by Julka ji, that with regard to recording of evidence, etc., I would say even now in our judicial system, in physical hearing also, the evidence is recorded through commissions.
Oh.
the court appoints a lawyer as a commission, and he records the cross-examination. Chief is being conducted by through affidavit, evidentiary affidavit, and same is the practice being followed in most of the arbitral tribunals as well. Yes. It's only the cross-examination for which the commission would be required, and because as very rightly pointed out by Siddharth, that the demeanor of witness and the fear that the witness might be tutored. So that fear, of course, is there on online recording of cross-examination. Well, this is our 6th webinar, which is being conducted on the platform of Webnyay. Okay. And we hope that many more enriching webinars will be held in future. The audience, the people, we request all of you to spare some time to join in future webinars also. On my behalf, I would request 2 things today. Siddharth, in the initial stage, had spoken about Webnyay's panel of alternate dispute resolution practitioners. Well, we are looking forward for your registration. The link is in the chat box. Further details about the fee and logistics will be provided to the applicants after registration. Well, as far as the platform of Webnyay is concerned, we are looking forward for giving you a demo of our platform, which has 2 parts. One is, of course, this providing the software for conducting online dispute resolution, maybe by a tribunal or a court, or through an arbitral tribunal, or providing a ODR with ADR, online dispute resolution with specialized trained arbitrators, mediators, and conciliators. So both in both form, we are providing that platform. And if anybody wants to have that demonstration, please reach us at the mail ID admin@webnyay.in. I'll repeat, admin@webnyay.in. So at the end, apart from thanking from the core of my heart to Shri Julka ji, I would pray that everybody should remain safe, wear mask, and be healthy in this pandemic period as well. Thank you very much.
Thank you very much. Thank you, Webnyay team, and thank you, Puneet ji. And wish you all the best, and Merry Christmas and Happy New Year to all your viewers and participants. Thank you.
Thank you so much, sir. Thank you for sparing your time.
Thank you. Pleasure.